Hi, I'm Katie from Virtual Legal, and in this video we'd like to talk to you about restraint clauses. A restraint clause is something that you'll find in a contract of sale, to purchase a business, in a franchise agreement and other legal documents. As the name suggests, a restraint stops the person from competing against you for a certain period of time in a certain geographical location. Also, an employer might have a restraint clause stopping you from working for a competitor for a certain period of time within a certain geographical area. When using a restraint clause, it's important to consider a tiered approach. So if 3 years seems like too long a period, a court might say, okay, perhaps 2 years or 12 months was more reasonable. So if you put into your documentation that the restraint is for 3 years, if that's not acceptable, 2 years, if that's not acceptable, 12 months, then you're protected from that clause being struck out of the agreement by court. The same goes for the geographical location. 10 kilometres may be considered to be too broad, but you're best to have that in your agreement in any event. So you would just have perhaps 10 kilometres if too long, then 5 kilometres if too broad, then again 3 kilometres. Keep in mind that in some restraint clauses, you'll be restricted from not only working for someone else, but from buying another business, having shares in another business, or being in any way involved in another business. And this may extend to your family and anyone else that you're involved in the business from which you're being restrained. Also, the phrase competing in terms of a competing business can also be quite broad. For example, if you had a coffee shop, you may be restrained from being involved or employed or having anything to do with another restaurant, cafe, superfood bar, juice bar. It just depends on the drafting of that clause, so be very careful. If you have any questions, please give us a call or jump online to our learning centre. We'd love to give you a hand.